what we have to say about Tavon. And I think it's important to note that at the time of these events, he was a 14-year-old young man, and he attended high school right here in Baltimore City. He has a very loving and supportive family who were quite pleased when we offered our services to assist him in his defense. My condolences are extended to all the families involved. This has been a serious tragedy of a major sort, and we understand that there's a lot of pain, there's a lot of hurt, confusion, and a lot of anxiety as to what the future will hold as it relates to this case with regard to our client, as well as the families who lost a loved one. And that is not lost on us as attorneys, that there's been a very serious loss for everyone. We have not seen the video. It has not been disclosed to us in any way, shape, form, or fashion. I'm not really sure if the State's Attorney's Office know that we're on board, but we are officially on board. We officially represent the arrestee in this case. We have been retained. In terms of the allegations where they have our client as the shooter, I think that if the facts show that to be true, then this case is very defensible. Someone wielding a bat, we would believe, is definitely deadly force, and the law allows deadly force to be met with deadly force. We understand the duty to retreat, but there's no duty when it's unsafe or the avenue of escape is unknown. We will color those defenses as we receive more evidence in this case, but we definitely feel that at least one or both of those defenses apply to this case. I do believe that the shooter honestly and reasonably believed that he was in imminent or immediate danger of death or serious bodily injury. I think ultimately the facts are going to show that this is a case of what we call perfect self-defense. And we look forward to the day when we'll have an opportunity to present our defenses in front of a jury of our peers, or we even look much more further to this case being returned to juvenile court, because quite frankly, that's where we believe it ultimately should be. We do not believe that this is a first-degree murder case. We do not believe that this is a second-degree murder case. And so we'll be working feverishly and very hard to have this case sent to the Division of Juvenile Causes. Thank you.
Everything that Jay Wendell indicated is correct, and I thank him for bringing me in on this, because it's a sad situation for everybody. This young man is 5'6", my height, and 126 pounds. I mean, he's a small child. He was 14 at the time. The deceased was over 6 feet and over 200 pounds, wielding a bat, like something out of Walking Tall. Drives across Light Street, parks over near Hooters, comes back across all these lanes of traffic with his bat. And you know, so that's quite frightening and quite menacing. This young kid has no history with the system. He has not been detained in any juvenile facilities. He was in school. He was not a troublemaker, and he was out there because he has been associated with older people who were ravaged either by the use of drugs or the sale of drugs, going in and out of prison, that type of lifestyle. And so he chose to do two things: sell water and the squeegee. On a good day, he'd make $200. On a bad day, he'd make $90. He would vacillate between President Street and over here on Conway. And he was just out there trying to make some money, honest money. And so, you know, for this to be visited upon him, he had no idea that day that anything like this would happen. So it's unclear as to really who did the shooting, but if it was him, as Jay Wendell indicated, it was certainly justified with this 6 foot, 200 and some pound guy coming at you with a bat. And why? Why? Because he was irritated, not because he was threatened. He got out of his car and walked across many lanes of traffic. He was irritated, and a lot of us are. But you can't just get a bat and go beat somebody down, some kid down, because they squirted water on your windshield. And there's no evidence that anything other than that occurred on this fateful day. And so, if in fact that's where we've come to, that you are allowed to use a deadly weapon against a little frail 14-year-old boy because they irritated you, then we have lost all sense of a civilized society. And so I'm glad to be a part of this because, you know, there are big issues we all know at play here, and politics has entered into it. But what we have is a little 14-year-old, just turned 15-year-old boy who went out there to make some money, honest money. And all of a sudden his life is turned upside down, and someone is deceased, and the family of the deceased lives are turned upside down. And why? I mean, it was an act of road rage. That's exactly what it was on the part of the victim. It was road rage. And so, you know, I don't know what it is about our society these days, but we get angry so quick, and we get violent so quick. And none of this had to have happened. None of this had. This was not broken wiper blades. It wasn't that he was assaulted while he was sitting in his car. He had some water squirt on his windshield and didn't like it. Drove after light change. He crosses Light Street, makes a left on Light Street, parks over there near Hooters, and walks across all these many lanes of traffic with this bat. Like I said, like walking tall. And going after some kid. It didn't have to happen. So
I'm wondering whether or not there was water squirt on his windshield, because I don't think the information was clear as to whether or not I don't think the information is clear as to what provoked this man into this aggressive, violent behavior, because I can't imagine that water being squirted on his windshield would cause him to park his vehicle 8 lanes across a busy road and pull out a bat and start wielding it at people. So perhaps there's some mental health issues on that side that were at play. We just don't know. Without any further information, we're merely speculating. What we do know is that, again, the charges against our client are extremely defensible. What we do know is that we look forward to our day in court when we can express ourselves more fully and present to a jury of our peers the full story and not a small portion of it, because it causes me great consternation to know that a 48-year-old man who's married with children would engage in this type of behavior. To me, it's outrageous, to be honest with you. When there was nothing to gain, the only thing that was going to happen from that encounter is either what actually happened or something close to it, where people were seriously injured or hurt. And so that should not be lost as well, that there was an aggressor that went and sought trouble. In fact, he was looking for problems. He was he decided that he was going to use his bat to solve whatever issues he had with those young people out there, merely just trying to do a job and service members of our community. So where the chips fall, we don't know, but we have extreme confidence on what we will be able to do once we get an opportunity to present our side of the story.
And then finally, let me just say this, and Jay Wendell made mention of it. The only reason this case is in the adult court is because he's charged with first-degree murder. If he's charged with second-degree murder or manslaughter, any of those things, he'd be in juvenile court because this is because of his age. That's why we are where we are, and so the hope is that the state will take a look at it and decide that this is not a first-degree murder case at all to even begin with. And then we can get to issues of self-defense and that type of thing if it becomes relevant.
Right, that's true. And I have to always go back to the fact that hopefully the state will determine that this is a matter for juvenile court, and perhaps it will not be in front of a jury. It will be in front of a judge to make a determination as to what types of services and how best we can rehabilitate this young man after going through this experience.
Has your client painted a clear picture as to what occurred between Reynolds and the teen after he got out of the car with the bat?
Well, right now we don't want to comment on anything painted by our client. We don't even know what information the state has. So me personally, I don't want to comment on much of the evidence. In fact, I took high platitudes in my remarks because I don't know what the video is going to show. And I just would feel more comfortable. I know what our defense would be if A, B, or C has occurred in the video, but I need to see the video.
So to your knowledge, there is video of the shooting and the confrontation?
Only because that's what was reported. I have no personal knowledge other than what I've read in the paper. And
That's correct. I mean, that's where we get it from. I think there's some legal documents that may reveal that they relied greatly on video. And I think the commissioners made mention of that as well.
okay.
To be clear, you're identifying your client as Tavon Scott.
That's correct.
Okay. And you both have supported Marilyn Mosby, and she's made a decision here in her office to charge your client with first-degree murder. What are your thoughts on
Well, I'm not sure she made that decision. I mean, the police department did. I mean, they arrested him and charged him with first-degree murder, and then, as is oftentimes the case, after the police charge you, the state's attorney's office will get the paperwork, and then they'll decide whether to increase charges, decrease charges, throw the case out. So I don't know whether she was involved at all in what charges were brought. I think that was pretty much the police department.
I think at the end of the day, it doesn't matter what she does. At the end of the day, we have a job to do. We're not here to make her decide how she's going to do her job. We have to do our job. Our job is to defend and protect this young man, and that's what we intend to do.
Have you talked with Tavon and his family? Was there any indication that he feared for his life as a squeegee worker, and do you think that justifies him as a minor possessing a firearm?
Well, no one knows. Well, we're not suggesting that or admitting or conceding that he possessed a firearm. But as to the first portion of your question, I think any kid that is 14 years old, 5'6", and 126 pounds, approached by a 6'2" man with 220 pounds with a bat, there's going to be some fear, instilled in that kid.
That man was a monster to these young people. I can only imagine, just remembering when I was 14 years old, to be approached by a 200-plus pound man, perhaps 250-pound man, wielding a bat. I mean, the question is almost rhetorical. Anyone would be afraid. There are people today who are 53 years old and perhaps even much older would be afraid of that same scenario. So I don't think it's going to be very difficult if it is determined that our client is the shooter, because we haven't seen anything, if that's determined, it's not going to be very difficult to establish an honest and reasonable belief of fear of imminent or immediate serious bodily injury or death, especially under the circumstances.
And the question becomes, you know, someone, you see someone get out of their car with a bat and they come across 8 lanes of traffic, cars coming and going. I mean, what do you think as they approach you? What are you thinking is in the minds of this person, that they're coming over to give you a handshake? They're coming over to, you know, offer you, you know, assistance with a bat.
Right.
With a bat, they're coming over to crack your skull. That's what they're coming over there to do. And so it's sad because it didn't have to occur. Like I said, it was an act of road rage
And then-
outside the car.
And then you really don't understand what's taking place because it's such an outrageous act. You probably don't even appreciate what's taking place until it's really too late. And then, you know, there's a curb nearby. You could trip over that curb. And if you trip over that curb as you're trying to retreat,
Traffic.
whether you're armed or not, if you're backing up and you trip over a curb, you can get battered to death by this 200+ pound man. And so we need to really understand what the evidence is. But if he's the shooter, I think when you start talking about duties to retreat and whether it's unsafe or whether there you know of any avenues of escape, you're petrified. You're paralyzed by fear for the most part. Because if there was a gun involved, well, not if there was, we know there was a gun involved. But if this man is still coming at you, and you're holding a gun, and you're 3 to 4 feet away from the curb, and you don't really know where it is, but you know it's around you somewhere, that makes it unsafe, perhaps in some respect, because this is a 14-year-old. So we have to always remember, we're not talking about adults. We're talking about children. This is a child. He doesn't really know how to respond to that level of force, that level of intimidation. So there's a whole lot going on. So we don't know what the facts are. We don't know what the video shows, but we do know the area. We've seen squeegee workers, as you all call them, but squeegee young people, in fact, we've all had experiences with them. Some good, most of them good, some unpleasant, but we all make it through. And I expect that this situation probably is an anomaly that will never occur again, but here we are today.
Can you talk about you mentioned about your client, without getting into facts of the case and trying to get the facts and things like that, just his concerns from conversations with you, dealing with what's happened in terms of going through court and all that stuff. Can you just talk about that a little bit?
Fear. I mean, fear. He's not. I know some people would imagine him as being, you know, stereotypically used to the court systems and all that. That's not him.
Not at all.
Not at all. He is out of place where he's being detained. True. And he's frightened. He's a handsome little man. He's a little boy. He was 14 at the time. Little small kid. No involvement in the juvenile criminal justice system, nothing. He's a kid, instead of mowing lawns or tossing newspapers, he's out there squeegeeing and selling cold bottles of water. And so he's frightened. He doesn't know what the future holds, and he's smart enough to understand that, you know, this is a flashpoint, you know, in terms of that, a lot that's going on in this city. So he's frightened. But you know, we just told him to keep his head high because from what we see, you know, he didn't do anything wrong. And the gentleman with the deceased, I think that I'd read that he had a bad encounter in the past with some squeegee kids, and so there must have been some lingering hostility towards these guys to do what he did. If you know, I mean, if my hat flew off, I wouldn't have parked on Light Street and walked across 8 lanes of traffic to get my hat. I just would have called it a day, right? So for him to come across with that bat he meant business, and he meant business because this wasn't his first time having an unpleasant encounter, not an illegal one, an unpleasant encounter. But Tavon is frightened. He's scared. So he's not some tough kid that some might want to imagine him to be. He's not that at all.
Do you know, was he interviewed with his father before you got a chance to represent him, and how they were able to determine that it was him, from what police believe? Did he live there in Essex, or did he live in Baltimore? I think you said he went to high school here in Baltimore.
I don't think any interviews were given, and quite frankly, that's what gives us certain concern as to, what information does the state really have other than they're saying that they talked to some witnesses and they were able to identify him. We don't know. And so, again, we're just going to wait, and we're going to ask that your viewing audience waits as well until we receive at least more information, even if not all the information, because right now he's just been, he's been identified, but there's been bad identifications in the past, and this perhaps could be one of those situations. And if it's something that needs to be dealt with in the future, and they determine that he was indeed the shooter because they have some credible identification of him, then we'll deal with those issues as they come. But again, what bothers us most is the premeditation. You talk about first-degree murder. You talk about the premeditation, the intentionalness of these events, and the deliberations. I see all those things with the aggressor who was wielding the bat. I mean, what was going through his mind when he decided? What was he going to do with that bat? Why did he swing that bat? Why did he walk across all those lanes of traffic? What was his intentions? That's what we cannot forget, because that, in my opinion, is the penultimate question. Although there's a final question, but certainly that's the second to last question that needs to be answered. And that's what we really want answers to.
May I clarify, is your client denying that he shot Mr. Reynolds or claiming self-defense in shooting Mr. Reynolds?
My client is not going to give any statements, and we're not going to report any of his statements. What I'm saying to you is we understand the burdens of proof in a criminal case, and we have to be convinced of multiple things before we even submit to the fact that they have our client as the shooter. And I want to know how he was identified as the shooter. And so we're not prepared to admit or deny anything about him, because it doesn't matter whether we admit or deny it. According to the charging document, they say it's him. But we're just curious as to how they came to that conclusion. And I'm certain that they'll let us know at some point, but I'm just not clear on it today.
You may or may not want to answer this. Your thoughts if your client, if he had a gun, if he was armed, if there was not a firearm on the scene in that situation, if he didn't have a gun,
I think
wasn't one close by.
I can answer that. I think our clients would have been seriously injured or killed that day by that overly aggressive man wielding a bat.
We know he has his bail hearing. Do you all plan to be present?
Yes,
Yes.
that's today. I mean, we don't expect that the judge will release him, but I do want to pick up on what Jay Wendell was saying about the premeditation. I mean, that is an essential element of first degree, and it's just regardless of who fired the shot that killed this gentleman. It's not first degree. It's not any premeditation. You're surprised with someone coming at you with a bat. That's not premeditation. And so it shouldn't even continue. And it's a little disingenuous, quite frankly, for the state to continue a first degree murder charge under these circumstances that they are fully aware of, including that the victim is going after these kids with a baseball bat. It shouldn't be first degree, and that's important, because that's, again, the only reason this case is in the adult system. We shouldn't even have to petition the court to have it transferred to juvenile court. It ought to be in juvenile court right now. By law, it ought to be in juvenile court because there's no premeditation. I don't care who did this. And so it really should not even be in the adult court. So we'll see what the state attorney's office does. We'll see.
And another thing that I want to point out, even if we see video, the video is going to be silent as to what's being said. And I would expect that there were certain warnings given as the shooter was backing up before he fired a weapon. I just would expect that because that's what our preliminary investigation shows. So, again, a video is one thing, but a video can't tell you exactly the words that were coming out of the mouth, like, I'm gonna kill your ass, I'm gonna beat the shit out of you, you're gonna die today. And words of that not only are you a 6-foot+ man and you have a deadly weapon in your hand that you intend to use as such, but you also have words to back it up. And so that, just to color the picture for you, creates even more of a circumstance whereby self-defense was probably appropriate.
And listen, if we all had a bird's eye seat to this, if we all saw it from beginning to end, alpha to omega, when we saw, as we watched this guy go through the light, cross traffic, park, get out with a baseball bat and start heading back towards these kids, crossing these many lanes of traffic, what would we have thought?
Right. He's not doing it quietly.
You're right. He's gonna hurt somebody. That's exactly what we would have thought. And the average reasonable person would have thought he's going back to hurt someone with that bat. And so you've got a 14-year-old kid. What is he supposed to think?
And again, we don't know how you react to these situations because kids, you could do fight or flight mode, you could just be paralyzed by fear. So all these issues are going to have to be fleshed out. And so, again, a silent video doesn't tell the entire story. It only tells part of it. So I just want you all, again, to keep your minds open, the viewing audience, keep your minds open, that the lawyers do what lawyers do. And we expect that this case should be resolved satisfactorily.
What other charges is your client facing, aside from first degree?
Well, it's customarily it's first degree, which will encapsulate all second degree manslaughter, all that. Use of a handgun in a crime of violence, possession of a handgun by juvenile. But so it's essentially, all part of anyone who's charged with shooting someone to death is going to be charged with, that panoply of charges.
Right.
So that's what's been leveled against him. But remember, this is the police department that did that. State Attorney's Office, I don't believe, was involved in the initial charging of him.
And even if they were, they can also review the charges after getting more evidence and make perhaps a more appropriate decision. But again, that's not our concern at this point. Our concern is defending this young man to the best of our abilities, and that's what we intend to do.
And to further clarify, you guys are confident at this point that he met his duty to retreat?
Depending on if he's been identified as the shooter, and I'm not trying to create this mystical, mystery about who the shooter is, but I need to know that he's been properly identified. Whoever the shooter was, yes, I do feel that that person's case is defensible.
And keep in mind now, we're talking about the state of mind of a person, whether or not they feel like they can reasonably retreat, safely retreat reasonably. Mm-hmm. You're talking about a 14-year-old.
Right.
You're talking about a little 14-year-old. His thinking is, or her thinking, a little 14-year-old. It's not going to be as mature of a thought process as a grown adult. And so, but, from what we've seen, I don't think anybody had an opportunity, any of these kids had an opportunity to retreat with this guy coming at them with a bat.
Yeah, this thing was happening fast.
It was.
And so it's an effort to retreat. The law says reasonable effort to retreat. And so that's, all those things. Words are going to mean something when we get to trial. I mean, in common parlance, it probably doesn't mean much. But when we get to trial, in a sterile courtroom, every word is going to have meaning. And a reasonable effort, whether it's backing up, half a step, 2 steps, as long as you're not aggressing forward. And so, we'll take a look at everything. When we see the video, we'll be able to analyze it. We know what the law is, and we'll be able to, better illustrate our points. But as it stands now, with a silent video, that'll just take us another 10 steps forward, but that's not going to take us across anybody's goal line. It doesn't even take us across the 50-yard line, because there will be witnesses out there who can tell you exactly what they heard, what they saw. And so if the video shows whatever it shows, that's fine, but we want to hear the audio in conjunction with the video, because that was going to help us develop what the story really is.